Hello, everyone. I hope you are well, despite the sad state of the world. We are very happy to start the last session of the webathon today. We have amazing speakers, and we're going to talk about our final thoughts on advancing social and economic development by promoting the rule of law. We have amazing speakers, and I will introduce them one by one before they speak. And since time is of the essence, I will start right now with Stefan von Raumer. Stefan has been serving his clients as a litigation attorney on matters of restitution law and property ownership law since 1993, and since 1997 in matters of constitutional law and matters governed by the laws concerned by the European Convention on Human Rights. He founded his law firm specialized in these fields in Berlin in 2001. Stefan is a member of the board of the Deutsche Anwaltsverein, German Bar Association. I'm sorry for my German accent. I know his French accent is amazing and his French is amazing, so sorry for the language. I mean, actually, the Stefan bios is like 8 pages long, so I have to shorten it. I'm sorry, Stefan. Stefan deals with the human rights issues that are addressed to the legal profession in Germany in his capacity as chair of the Human Rights Committee of the German Bar Association and as commissioner for European affairs of its Human Rights Committee. He is a spokesman of the German Bar Association at the Dutch Institute für Menschenrechte, DIMR, German Institute for Human Rights. Stefan, I'll let you the floor. Thank you very much.
Thank you very much, Thierry, and your German accent was not so bad. So thank you for the introduction. And I'm very happy to be here. I thank AIJA and I thank all the organizations and all speakers and everybody who was making this wonderful event possible. I think it's a very important one in those times. We all have to exchange our experiences in the field of the rule of law and its challenges. I think really that we're living in times where it's very important that lawyers work together and lawyers organizations work together. So, for example, I'm also glad to be in the CCBE, which is the roof organization of the European lawyers organizations. And I know that all the other organizations that were organizing this event also have the same spirit. If we see situations that come up and that are really targeting the rule of law in Europe, but also out of Europe, if we are thinking of Afghanistan, the situation there, we are thinking about this very, very sad war in Ukraine. So we have a lot of challenges that come on the rule of law in Europe. And I think everybody of us has his own topics with that on the desk. So I think one of the most important things is how to work together as lawyers and as lawyers organizations to cope with this challenges. And I don't only want to mention the dramatic challenges we have, but also the other challenges we will have on the rule of law that are more on the economic side. We have the money laundering law that is very important for lawyers, and sometimes has some struggles with the secrecy of our profession. We will have the delivery chain law soon in all of our European countries, but also a lot of challenges for the lawyers. And we have the big topic of climate change that also will be a very important topic for the future of European lawyers, and a big field where we'll have to have a lot of work. And I think mentioning these topics, we see that it's more and more important to really work together internationally, because all these laws have effects on lawyers in all the countries. So that's a bit the thing I want to speak about. I want to just shortly mention a small example between a lot of others. There are a lot of very interesting cooperations of lawyers organizations. I mentioned some of them. One is the CCB, for example, or also the American Bar Association is a member of the organization team of this year, and AIJA and others. And this example I want to mention is the so-called, what we call Weimar Triangle of Lawyers. The idea of this expression, Weimar Triangle, came from 1991, short after German reunification, where the ministers of foreign affairs of 3 countries, Poland, France, and Germany, founded a communication platform on a more informal basis, so not so formal diplomacy, but informal diplomacy and informal talk between the ministers of foreign affairs between these three countries. And this was what we call Weimar Triangle. And now we continued the idea of that expression by founding a Weimar Triangle of lawyers in November 2019 with the Paris Bar Association, the Warsaw Bar Association, and the German Bar Association, where meanwhile I'm also one of the vice presidents of the latest German Bar Association. The idea is to have a format to join efforts for the protection and maintenance of the rule of law as one of the fundamental principles of democratic societies. So as well as to promote and support the independence of the judiciary and the legal profession in Europe. So this was the idea. And we can see that the French, the Paris and the Warsaw Bar and the German have a lot of topics on their desk that are of interest for all the three countries. In the beginning, the first meeting was on 29th November of 2019. So representatives of the three lawyers organizations I just mentioned came together, and we especially had a lot of concerns about the judiciary reform in Poland. And that's what we shared our opinions to. And I saw that because, I know the European Court and Luxembourg's decision on Poland. There are a lot of them, and it's a kind of real fight between the Polish government and the European Court. Every European lawyer realizes, but it's something completely different to read these decisions of the European Court and to speak to my very beloved friend and colleague Mikołaj Pieczak, who is Dean of the Regional Bar Council in Warsaw, by describing in what way these decisions of the European Court in Luxembourg are understood in Poland and in which way the Polish courts deal with that, because this is a kind of knowledge you only get perfectly if you're a Polish lawyer. For me, even I don't speak Polish, so I know the European Court of Luxembourg decisions, but I don't know the reaction of the Polish courts exactly. I can read it in the press, but so this shows that it's very important, really, because all of these lawyers have special knowledges in their own law. They have the cases on the desk you only read in the newspaper. So I think this is one of the major important effects, is specific knowledge of the national law, of the national jurisprudence, combined with what we all know, the European law and the European Court's decision, or maybe also European Court of Human Rights decision. So we continued that, and it was this very frightening development in the Polish legal system that was the center of what we were discussing. So in September 2020, we came together to discuss the latest development, the latest discussion, the decisions of the European Court in Luxembourg and the reaction of the national courts, but also the situation in Belarus that was very worrying, and even had some colleagues in Belarus. Since a long time, I know the situation in Belarus a bit. Also, the CCBE granted a Human Rights Award for Pavel Sapelka, one very beloved colleague in Belarus, who now works in the underground since years, since he made the mistake to defend the non-compliance that had a bad death penalty. Then he lost the possibility to work as a lawyer officially in Belarus, and he went into underground in the organization Vyazna to help lawyers and to help the rule of law from the underground. So this is the situation in Belarus, which went worse and worse since the last elections. As far as I can say, a lot of our colleagues that defended and they were working as lawyers for candidates in the opposition of the actual government in the elections also had a lot of legal problems, even went to prison for simply doing their job as lawyers. And I know some of them who had to leave now Belarus after really trying to still work there as lawyers in this very complicated and risky environment, and now really had to leave to the neighbor countries. And also my Polish colleagues and my French colleagues knew a lot about that. So this was what we were discussing then. And then we had a big conference in 22nd October on the defense of law. We had very interesting guests there. We had also, for example, one Raphael Kampf's lawyer from the Paris Bar Association, and to come maybe a bit also to France, who really was worried about what happened in consequence of the terrorist attacks of 2015 and the state of emergency in France, and really is also talking of erosion of the rule of law in France by the way, that I know from one of my cases at the European Court of Human Rights, where it's coming to so-called apologisme de terrorisme. So these are cases that are run by French courts in a very harsh way, so that even Human Rights Watch and the UN Special Rapporteur is now very worried about the way of too broadly extending this criminal law on apologisme de terrorisme. So I have one of the cases that the European Court of Human Rights just accepted against France. There's no decision, but it's already accepted, which is already a small success. So I know that there are some worrying situations also in France, but even in Germany, for example, we had, to also mention us, we had Minister of Justice and Consumer Protection of Germany representative here, Gabriel Niratzik, who informed us that I was a bit shocked about that 1/3 of the German public has no confidence in the judiciary, and really stressed the need to a real cooperation between different legal professions. So 1/3 in Germany, which I thought is we have a quite good status in our rule of law, and we have a quite good and reliable justice system, but also hearing that only 1/3 has no confidence in the judicial system is also an alarming situation. I could go on long and long about the rule of law situations in that 3 countries and the way we cooperate. There was a lot of interesting stuff for you to discuss, and so I don't want to be too long, but maybe I also want to mention our cooperation. And I was very glad, I must say, that we had the Weimar Triangle of Laws when this sad war in the Ukraine began, because this is a challenge for the rule of law in a way I never would have imagined before, I must say. We all face in Europe, and to have a strong cooperation of lawyers organization and trying really to organize ourselves and to help each other. So already on 29th of March 2022, the Weimar Triangle of Lawyers published a very strong statement against this law, really also very clearly speaking about the legal issues of that law, and that is really unlawful under international law without any doubt. But then also, because for the moment, lawyers organizations are a bit helpless. We can't change the situation we have on the ground. There is the war, and we won't be able to stop it, I fear. But okay, then we have the consequences of that war, that a lot of them are existing, and one of it are, for example, the refugees. And our Polish colleagues were the one in the front line when the refugees came. And it went so fast that every day the numbers that you had become told before were wrong then, and it went up from 1 million to 1.5 to 2 million so fast that you even couldn't follow that. And all that went also on the Warsaw Bar. They had a lot of struggle to try to deal with all the questions. And then we made our cooperation work on different issues. For example, also organizing a platform that are now working in all the 3 member countries of the Weimar Trial to help colleagues that are refugees now coming from Ukraine to find a job in law offices. For example, in Germany, we do that. I just realized that we have already 50 colleagues that now have found a job in Germany because we use this network. And also we have information platforms on all kind of asylum law and questions that may come up there. So it's, especially in this crisis situation, I think it's very, very important that strong lawyers organizations work together internationally. And I think I will finish my report on that. That would be a lot to do. I'm so sorry that I can't be part of the discussion, but unfortunately I have to leave to get my flight to Dublin and the CCBE Standing Committee I will be member of. But not without saying once more thank you to all the lovely organizers and all the people that we don't see now. Like, for example, Arrest. Thank you, Arrest, for the very good and professional organization, and AIJA and all the organizations that work together, and all of you who put their time here in speaking, in sharing your experience, but all the others on the other side of the screen that are interested on the rule of law. And already this interested on the rule of law is very, very important. As long as we all are interested in what's the state of Europe, of the rule of law in the world and Europe, there is hope. that things get better, and it's time that we need this hope. So thank you so much. And I wish you a fruitful ongoing discussion and fruitful closure of this incredible webathlon. Thank you so much from Berlin.
Thank you very much, Stefan. I may add, because I can't see any question on the chat, that the Weimar Triangle was very helpful with regard to obtaining, being provided with great advice from the Polish bar, who was amazing, and all Polish people actually, managing to deal with so many refugees and helping us to understand how we could do better in our countries. And they were very, very helpful in that regard. And so it's interesting to see lawyers working together and helping other lawyers having problems. Stefan, many thanks. Danke viel. I know you have a plane to catch, and I can't see any question for you on the chat, unless other speakers want to ask you a question now. If not, we will leave the floor to Edmond, who is not among us, unfortunately, because he's in Amsterdam, busy pleading a case, I think. So I will introduce him, and we recorded his speech. Edmond Claude Fréty is a French lawyer. He's a former member of the Paris Bar Council, member of the Human Rights Commission of the Paris Bar, and member of the ECBA, European Criminal Bar Association, and current Secretary General of the International Observatory for Lawyers in Danger. He's a graduate from the University of Paris 1 Panthéon-Sorbonne and the University of Birmingham. Edmond was elected first secretary of the conference, which is in French, secrétaire de la conférence, which means he's very eloquent. You're gonna check that in 2 minutes. His practice is focused on litigation, mainly in white collar and criminal law. He chairs the association called Cerveau Droit, which means in English, right part of the brain, an association of the Paris Bar Association, which aims to bring together lawyers and scientists to discuss the existing or future relationship between law and neuroscience. I'll let you launch the Edmond speech. Thank you very much.
My name is Edmond Claude Fréty. I'm a criminal lawyer in Paris and a former member of the Paris Bar Council, current member of the Human Rights Commission of the Paris Bar, and current Secretary General of the International Observatory for Lawyers in Danger. I'm afraid I won't be able to be with you, so the AIJA authorizes me to speak about the shelter program of the Paris Bar with a recorded message. So I'd like to express my sincere thanks to the Webathon for allowing me to speak that way about the REPI program. As you know, the COVID-19 epidemic has hit hard lawyers worldwide, and violations of the rule of law are increasingly frequent, and lawyers working in sensitive cases are now more exposed and isolated than ever. So on the occasion of the International Day for Human Rights, the Paris Bar has therefore decided to set up a hospitality and shelter program for lawyers under threat throughout the world. The innovative initiative seeks to give lawyers the opportunity to spend some time away from their respective countries and escape the stressful and difficult situations they operate in, and to keep those most at risk away from any immediate danger. The lawyers may therefore find some respite and experience the stress-free environment provided by the French capital, whilst developing their professional networks and skills throughout their stay. The first beneficiaries of the program were welcome in 2021, and the feedback is extremely positive. This program is a short-term one, as we believe, but it is more adapted to the professional life of our colleagues. Furthermore, the objective of this program is not to encourage our colleagues to go into exile, but to provide them with a breathing space in their difficult lives. We are nevertheless aware that applications for refugee status once in France are quite possible, particularly if the level of risk is too high to envisage a return. Thus, lawyers benefiting from the scheme will be hosted for a fixed period of between 2 weeks and 3 months. The program will cover all costs and make the necessary arrangements for the lawyer's stay from departure to returning home, which means travel, accommodations, livings, costs, and so on. The scheme is open to lawyers of any country. We do not exclude any country from this program. We are aware that the threats to the rule of law in some EU countries and the sensitivity of certain issues can lead to situations of threat and risk for our European colleagues too. So the requirement for protection stays in Paris are as follows. First, the lawyer is threatened by governmental or non-governmental actors because of his or her activities. Second, the lawyer is still active in his or her country of origin or has only recently left the country to escape danger. And thirdly, beneficiaries will be chosen based on predefined criteria, including how high and imminent the risks are. A secure application and communication system is systematically offered to candidates and can be set up at their request. The Paris Bar Shelter Program team reviews the application documents and the personal statement of the lawyers, contacts the reference persons, and if necessary, ask the applicant for further information. If all requirements are met, the Paris Bar Shelter Program informs the selection committee consisting of key figures of the Paris Bar. The selection committee will select the successful candidates. The aim of this program is not to welcome a very large number of beneficiaries, but to welcome them in the best possible way within the framework of a stay specially adapted to their needs and wishes. Confidentiality regarding their visit and the reasons for their visits can of course be respected throughout the stay. Every effort is made to allow them to continue to work and follow up on the cases if necessary. They can benefit from a workplace separate from where they are staying, allowing them to keep abreast of the cases. The lawyers taking part in the program will also be able to receive training and access various legal libraries and databases. Meetings can also be arranged with organizations, the media, NGOs, and so on, depending on the lawyer's wishes. Medical and psychological support will be offered routinely for this respite period. The Paris Bar Association has signed a partnership with the Primo Levi Psychological Care and Support Center. The beneficiaries of the program can benefit from consultations with the support of an interpreter if necessary. This aspect seemed essential to us because we note that lawyers who work on difficult cases very often neglect to take care of themselves and their psychological and physical health. The last beneficiary we received in March 2022 was a lawyer who had spent more than 10 years in a military prison in the Democratic Republic of Congo. He was sentenced to death and later pardoned. After 10 years of detention, it was essential for this lawyer, who continues to practice, to have a complete medical checkup during his stay in Paris, which would have been impossible in his country. The number of lawyers in danger is constantly growing, and with them, all the people subject to the law suffer. Because without the possibility of a defense, no one can live free. This is why the REPI program, the shelter program of the Paris Bar, was born. A lawyer who finds refuge in Paris is a lawyer who pursues his commitment to the defense. And by defending our colleagues, We are protecting the principle of the rule of law and making commitment to sustainable development. The REPI program is a concrete proof of our determinations. And I'd like to add also that, driven by the strong will of the former president Olivier Cousy, who passed away recently, the Paris Bar was actively involved in designing and implementing the French presidency's Marianne Initiative for Human Rights Defenders. It is essential for the Paris Bar to work with all institutions or civil society organizations that protect human rights defenders in order to share our practices and solutions to improve the protections of those under threat. Whether they are journalists, lawyers, or activists, the persecution they face is often similar. The Paris Bar Associations advocates for the recognitions of lawyers as human rights defenders and encourages the different bars to carry this message to the national and international institutions. Thank you very much for your attention. Bye.
Thank you very much, Edmond. The REPI program at the Paris Bar is amazing because it's really creating a breathing space, a rest for the people who come to Paris for a period of time. And when you meet them, it's amazing. So we invite all the other bars to implement the same program, and if they don't, we are at your disposal to help you implementing it if you need or want to. Thank you very much, Edmond. We're going to listen now to Stéphane de Navacelle. Stéphane was a member of the Bar of New York before he was a member of the Paris Bar, which explains his very good English. Stéphane practices corporate litigation, predominantly in criminal law, regulatory, internal investigations, compliance, complex litigation, and arbitration. He is also a former member of the Paris Bar Council. Stéphane, we listen to you. Thank you.
Thanks so much, Thierry. I had prepared a few words on really focused on economic development as a means to promote the rule of law, which is our issue for this final panel. But the two previous speakers have really touched upon an issue I would like to labor a little bit. So I'll shorten my initial intervention to still be within the 10 to 15 minutes, but talk about a few experiences that I have been able to have, and I think it will be helpful to the group at large, of all of those involved. Maybe not helpful, but maybe of more interest to all of those involved in this webinar and this initiatives. As some of you will know, we started this last year with the initial one, which was a great success, which led to this second one. And unfortunately, it appears that the state of the world has probably worsened, or maybe most certainly worsened, and is not on a good path. And the issue I'd like to labor is really, what do we as lawyers need to do? And Stéphane and Edmond have addressed a number of issues, and I'd just like to add a few. Do we have, as legal professionals, a specific responsibility? And I say legal professionals because I mean people on the bench, I mean people at the bar, I mean legal professionals in-house. In every stage of life, in every decision you make, you need someone you can trust. And regardless of how you practice the law, you have an obligation to your client. As a judge, your client is the citizen, is the person sitting in your court. And you will provide the rule, which is a law, which was decided in a democratic fashion, hopefully. And you will also provide context and advice. And there's a real debate as to whether the rule of law generally has also been tarnished by the whole set of soft laws. In France, we call it le droit mou or le droit souple. And whether that has created uncertainty, and whether the totally open, uncensored, uncontrolled freedom of speech is a good thing, or has it caused more harm to the democratic process, to individuals, to the free thinking and the possibility of a proper, sound public debate? And of course, here I'm also thinking of the influence of social media on democracy, and the fact that Twitter is apparently going to be in the hands of one person. So we as lawyers have a specific responsibility. Again, members of the legal profession, and we will help the world progress because we will have allowed a sound economic development. And ultimately, the person on the street, wherever he or she is, wants the same thing, a better life for the kids and a better world for everyone. And we've shifted from a situation where we were advising as to what the rule is to advising as to where our clients, again, regardless of who they are, should go. And it goes from this is your risk to try to avoid it, do less harm, less exposure, to do as good as you can. And we've recently passed a law which may sound absurd, maybe from an economics perspective, which creates the idea of a entreprise à mission, we say in France, that a private sector company can have a role other than a pure economic one. And with all the ESG reporting and obligations that stem out of that. And here again, the legal profession generally needs to adapt, and we need to hold each other to a higher standard. And Stéphane and Edmond spoke of a number of ways the solidarity amongst lawyers can reap amazing situations. And we need to bring rationale in this mess. And our role is to maybe allow others to be able to speak by bringing down the debate to actual arguments and not howling with the pack, if you will. I was a few years now back in a West African country, and the local bar president explained this to me. He said, for us, it's very simple. There are two bad ways that countries look at us, and one way that we would like to be looked at. And the first one is the foreign companies come in, they see our resources, they create considerable debt. The benefits of what they are doing really goes to the happy few, and then they leave. There's another approach, which is one where the change in the laws are forced if you will, by the economic actors, the participants. And once the proper legal framework is there, investment will come in, but it will come in a way that ultimately is not very different to that first investor. And he said, we're now educated enough. We know we've been to the same school as everyone. And what we want is to be treated as equals on a long-term relationship. And now we need to be very demanding of ourselves. But if we are considered as equals, we will be able to contribute to the sustainable growth. And of course, he meant it as lawyers, but he also meant it beyond. And today, the pressure that is put on companies is such that, as I sometimes say too fast, companies fear more Twitter than the prosecutor. They are confronted to a situation where they are under so much pressure that they would rather divest because de-risking is so costly. And we really need to work to a middle ground in the compliance system that we put in place to avoid the divest, which is the most catastrophic solution for those countries locally, because quite simply, it means that they will be left only with those investors and private sector people who behave in a way that is at least unethical. And the de-risking by a considerable cost of compliance and controls will have a similar effect, because it will make everything much more costly for those who have the least capability to spend, if you will. And the solution is that of my colleague I was speaking to, which is one of teaming up and finding the people that are in every country happy to look at this with a long-term perspective. And there are many organizations, and the bars are one of them, and this Webathon to raise awareness is another. But we should certainly turn to all the organizations that are capable and willing, and hold everyone to a higher standard. I half apologize for this off-track comment, more than a comment, which was too long. But I really think the key lies with each one of us individually. I'm just going to say a few words, 5 minutes, I promise, on the issues that I was supposed to address, which are really the issue of how to advance social economic development by promoting the rule of law. And that is by creating norms that people can rely on, and norms that can impose on people. And it all, to some extent, starts in 2011 with the UN Guiding Principles on Human Rights, which basically turns to the companies, the private sector people, also the private sector people, and telling them, you need to invest in a way that is responsible, and you need to know basically what you're doing. And you need to do your homework. You need to review your transactions to make sure you are acting in a way that is responsible and respecting human rights. In France, in 2017, we have a law called le devoir de vigilance, which lacks a real governmental body, but I'll talk about it a little bit more. Germany has adopted a law quite recently, and it is, I understand, to come into effect this year, and the EU has proposed a draft directive. So just a few more words before I on this specific issue before I pass on to Jan. How do companies how are they held accountable for human rights in the way they do business? I've mentioned these three initiatives through the compliance, which can be a threat if it creates a burden that is not manageable, and as such we have to turn to organizations so it becomes a market practice. Of course, the fear of enforcement is key. And for that, we need to have the right tools. France adopted a DPA, but there are only very few countries that have them. They are, of course, a very important tool. And we have a big debate actually globally on the role of victims in DPAs. Are they not left aside, especially in the US when you see that there is virtually no judicial review. In France, we have a judicial review, but it's probably too strong because it creates too much uncertainty. But the real question is, what can the victims do to get remedy? And part of the answer is in the statement of facts that come with these DPAs, CGIP in France. We also have the whistleblower systems, which are essential. The EU directive on the issue was passed that makes it now a continent-wide obligation, and of course relying on third parties, NGOs, bars, unions, and so on and so forth. I'm not going to go into the details of the French duty of care. I'm happy to share documents. I've spoken too much already, but it's available online, and I'll be happy to share. Maybe just to pass on to Jan. The idea is of all these laws is that you have to comply with the human rights protection. It also adds on the environment as an issue, increasingly important, not increasingly important, very important, but companies are becoming increasingly aware of and feel compelled to address. And of course, you need enforcement, and so you need the judge's involvement. And I'll just give one example as a conclusion. It's in 2019. A few NGO sent a notice to the French oil company Total, telling them they were failing their duty of care with respect to climate change and the environmental impacts of its subsidies and suppliers in a given country. And the first step of the success of that procedure, that it was accepted as such. And these NGOs had standing in French courts to do so. And you see that instead of creating extraordinary and extremely costly international courts and so on and so forth, it's really about having the right laws internally and turn to ordinary justice, which needs to be effective, rather than exceptional justice, which is never a good pair with the rule of law. Thank you so much, and I hope it was okay for me to derail from the initial intervention. Thank you.
Thank you, Stefan. Actually, you were just right on time. Great, perfect. Thank you very much. I will give the floor to Jan Aguila after introducing him to you now. Jan Aguila is a professor at Sciences Po in Paris and partner at Bredin-Pratt. Before joining the bar, Jan was a judge at the French Administrative Supreme Court, the Conseil d'État. He teaches public law and global environmental governance. He's one of the initiators of the Global Pact for the Environment project in his capacity as chairman of the Environment Commission of the think tank Le Club des Juristes. He coordinated the work of an international network of some 100 experts who drafted the first draft of the pact. He heads the Global Pact Coalition, an NGO accredited to UNEP, which aims to promote the international recognition of environmental rights and duties. He is also the author and co-editor of numerous books and articles, such as A Global Pact for the Environment, Legal Foundation, Droit Public Français et Européen, or Principios de Derecho Ambiental y Agenda 2030. Jan, the floor is yours. Thank you.
Thank you very much, Thierry. Yes, my speech is a kind of return on experience because, as you said, I was one of the initiators as a lawyer of a project of an international treaty, the Global Pact for the Environment. And I want here to testify on this experience. I will do that in 3 points. My first point is to say that as a lawyer, I believe in the power of law, especially to protect the planet, because at the end of the day, we need law, we need obligation, we need prohibition, we need a legal framework, we need law. It will be my first point. Second point, the law needs texts. We need text to be applied because texts for lawyers are weapon. And third point, yet, however, there is a text missing. In international law, as strange as it may seem, there is no text, no legal text that recognizes environmental rights. And it was the goal of the Global Pact for the Environment. And it is now the goal of our coalition. We created a coalition, the Coalition for a Global Pact for the Environment. And I'm going to say a word on that. So first point, I believe in the power of law. Of course, as a lawyer, I believe in the power of law. I believe in the effectiveness of the law, in particular to better protect the planet. Of course, the law is not all. We need money, we need policies, we need tax, we need many things, we need education, but we need law. The law is the heart of society. The law establishes a framework with prohibitions, with duties, and with rights. And we need rights protected by the law. And in the field of the environment in particular, I believe in a kind of binomial. We saw now in many cases a kind of binomial with citizens and judge. The citizen and the judge together can be the guardians of the law, and especially the guardians of the promises of the states. Because when the states sign a treaty, they take commitments. And the question is, who is going to check that they apply this commitment? And the answer is the citizen plus the judge. You can see it in climate litigation in the Netherlands with the Urgenda case, a very famous case in climate litigation. And in France with the Grande Santé case, it's always the same configuration. Citizens bring cases with states before the judge, and the judge ensures that the law is respected by the states. And for example, in France, in the Grande Santé case, the judges, Conseil d'État, order the state to take new measures against global warming. So I believe in the power of law, and more profoundly, if I believe in the power of law in the field of the environment, it's because one of the abysmal questions We can see it now. In environmental matters is how to change our behavior. Because we know the crisis, we know the seriousness of the crisis, we know what to do, but we do not act. And why are we not acting? Because behavior change is difficult. It's very difficult, even for us committed citizens. It's difficult to change, and that's why the law helps. We need constraints, we need obligations, we need prohibitions, we need law. So I believe it's my first point in the power of law. And second point, the law needs text to be applied. We need legal text. I mean, legal text with legal value, not only soft law, because in international law, we have many declarations, guidelines, texts without legal value, soft law. But, you know, as a lawyer, I don't care about soft law. If I go to the court, I need hard law. I cannot invoke the Rio Declaration, the famous Rio Declaration, which is the very important text, but I cannot invoke the Rio Declaration before a court. So I need legal text because for me, texts are weapons. I like this idea that texts are weapons for lawyers. To take a concrete example, if a company pollutes your land, and if you want to sue this company in court, you need a legal basis. For example, you can argue that the polluter violates your right. For example, the right to a healthy environment. But the issue for the lawyer, for the judge, is that this right is not often recognized by a text. In particular, in the USA, you know that there is a movement now in the USA for the Green Amendment to recognize the right to a healthy environment in the Constitution, because we need legal text so that this right can be invoked by citizens before courts. This is my second point. We need legal text to protect environmental rights. And third point, however, there is a text missing. As strange as it may seem, in 2022, in international law, there is no legal text recognizing environmental rights. We have text recognizing human rights in general, but no text about environmental rights. There are many technical texts, sectoral texts in many fields that, like the Paris Agreement, it's a very important treaty, but the Paris Agreement regards only climate, and it's very technical. It's not about rights. So there is a kind of missing piece. If you see the picture of the international environmental law, there is a missing piece. There is no text about our rights in the field of environment. That's why for a long time, lawyers have been proposing the state to adopt this kind of text, a founding text, you know, this kind of short text, like, you know, with 10 principles, like a very important declaration, Universal Declaration, for example. You find this idea in the Brundtland Report in 1987, before the Rio Declaration. You find this idea in a project of the IUCN, the International Union for Conservation of Nature, very important NGO. It's a long time ago, in 1995. So no, it was the subject of the Global Pact of the Environment. And if I have 5 minutes, yes, in 2017, we draft a pact. The story began in France with the Club des Juristes, with the Environmental Commission of the Club des Juristes that I chair. And after that, we draft a pact with around 100 lawyers from all over the world, with great professors, lawyers, judges from 40 nationalities. And we draft a pact. And at the beginning, it was an incredible success story because in 2018, the General Assembly of the UN, there is no more important than that. The General Assembly of the UN adopted a resolution entitled Toward a Global Pact for the Environment, but it was only a resolution that opened negotiations between states on the pact. And the negotiation, unfortunately, met the oppositions of some states, and to not mention them, the joint opposition of the United States and Russia. The United States and Russia were allies in this case. So since then, the project of the pact is forgotten, is at a standstill. Nothing happened. But on the other hand, we had another great success last year, and it's a kind of prolongation of the spirit of the Global Pact. Last year, in the end of 2021, the Human Rights Council adopted a resolution recognizing the right to a healthy environment, and it was the first international recognition of the right to a healthy environment. And now, next step, it is in New York, before the General Assembly of the United States. We are supporting a draft resolution of the UNGA on the right to a healthy environment, and it could be adopted by the General Assembly itself. The project is supported by many NGOs and states, and we are optimistic. We think that it could be adopted this year. So at the end, in the Global Pact, you have the title. It doesn't matter, pact, covenant, charter, it doesn't matter. And there is a spirit, and the spirit is very important for us. It is clear that we think that we need a founding text, a text that recognizes the right to healthy environment, the right to clean air, the right to safe water, the right to public participation, and of course, the duties of states, duties of companies, duties of citizens to take care of the earth. We need a global framework, a kind of umbrella text that bring together all these rights and duties. On another note, on a deeper level, in the context now, in these difficult times with COVID, with war, we can think that we need a new impulse to international cooperation to build back better, and this kind of text could play a role in this field. So, just to conclude, if you want to know more, you can see our website, because we created a coalition, the Global Pact Coalition, and you can go to our website. It is globalpactenvironment.org. And just to conclude, in 2017, during our work on the Global Pact, we had a kind of slogan. We said, with a very small group of people, we said, those who think that it's impossible, please don't bother those who are trying. And it still applies today. And I think that we can go further and together, and maybe with you, if you want to help. Thank you very much.
Thank you very much, Jan. That was very, very interesting. I don't have any question in the chat, so I might just underline something because I'm more on the economic side than you are, and I'm just wondering whether we have a new duty. You know, Stéphane mentioned other countries, but talking about our countries, we're many French around the table, so talking about Europe or Western, so-called Western countries, focusing on what we do. I'm just wondering whether we should, as lawyers, educate, teach, talk, discuss to businessmen about the rule of law, about what they owe to the rule of law every day, because we're losing something with the general public, at least in France somewhere there, where it looks like it's a given, right? So it doesn't matter because we have it. And so we're trying to tell them that it's not a given, and we have to be very concerned, focused, and explain to a lot of people. And we lawyers know that very well. I'm talking about all the laws, exceptional laws we had in France because of terrorism, COVID, maybe now the war we'll see, which really changed the legal landscape, and which gave, like, you know, very bad habits to politicians. And we're like sometimes lost, but we need to, I'm talking, my clients are businessmen, right? So I keep telling them, be careful. Everything you have here doing business is thanks to the rule of law. And we need to do that with a lot of people, including businessmen. A new task for lawyers, if you don't have enough already. I would like to thank you. I mean, it was amazing. I mean, we're very good. I say we, like like I'm still in AIJA, but I'm far too old to be in AIJA or represent AIJA, but be nice with me. I like to do it. We're very grateful to the speakers to dedicate part of their precious time to come and speak to the webathon, because it was very, very interesting. And I will now give the floor to someone with whom I have a very strong AIJA bond, who's French, another French again. François, I'll let you conclude that amazing seminar and event. Thank you very much to all.
Merci, mon cher Thierry. And thank you, Edmond, Thierry, Stéphane, and Jan, for this very interesting wrap-up session. I will limit my own wrap-up to acknowledgements and thank yous. And I'm in 2022 more than ever, I am very proud, not to say moved, to see such a universal commitment of the world's lawyer to the rule of law. It was quite a feeling, dare I say, to go to bed very late yesterday, knowing that panels would continue all night long to discuss the rule of law worldwide. And therefore, on behalf of AIJA, I would like to thank the UIA, the ABA SEAL, the Law Society of England and Wales, and the IIBA to come together again for the second edition of the Rule of Law Webathon. Bear in mind, throughout those 24 hours non-stop, important topics were discussed restlessly. Access to justice, climate change, women's rights, plight of refugees, civil liberties and fundamental freedoms, forced labor, independence of the judiciary and the legal profession, freedom of the press, notably, but not limitatively. And like Jan say, we believe in the power of law. I would like to thank all the speakers and moderators of the 12 panels from all around the world and all bars, legal associations and lawyers who participated to this edition. And a big nice shout out to Joseph, Jerry, Jacqueline, Christina, David, Marcos, Lisette, Lourdes, Romina, Marie-Pierre, Vicky, Paula, Anna, for their amazing energy and constant involvement in human rights. The warmest thank you to Oreste Soras for supervising the project restlessly for AIJA throughout the past months. And a deep respectful bravo to our Human Rights Committee, Stéphane de Navacel, Clara Poglia, and Martijn Burgers for their hard work in defending the rule of law throughout the year with so much energy. I am looking forward for the third edition next year. I hope you've enjoyed those 24 last hours. Bear in mind, if you've missed a panel, know that within a couple of hours, all videos will be available on the YouTube channel of the Rule of Law Webathon. And without further ado, have a very good morning, afternoon, or evening. Goodbye, everyone. Thank you.